Pre- and postnuptial agreements. Prenuptial agreements can be a very useful tool for two parties contemplating marriage. Frequently, parties contemplating marriage are not aware of the rules of community property and what will happen in a divorce. Frequently, it is a good idea to consult a lawyer if you have significant separate property assets. Understand what happens to those assets if you get married. There are certain rules that you can preserve those assets. Premarital agreements cannot, however, deal with custody if you intend to have children. Both parties to a premarital agreement need to have counsel. Both parties have to disclose their assets and their liabilities. Premarital agreements can determine what will happen if the marriage terminates. It can determine how premarital property will be preserved. People aren't aware of the fact that when you bring property into a marriage, it will stay separate property unless there are community efforts expended on that separate property, and that will create jurisdiction over a family law court. That can be prevented or shared. Parties can make decisions about what kind of property they're going to acquire and how they're going to deal with their finances. Frequently, premarital agreements are important to people who are involved in subsequent marriages who have already been divorced and have received the property that they need to preserve. Postmarital agreements, however, are less frequent, but deal with people who wish to order their matters if, in fact, for example, one party is engaged in sort of risky investment activities. A postmarital agreement can deal with that. If the parties have serious disagreements, how they're dealing with their community property, postmarital agreements can help them resolve those issues so that the marriage can proceed and one party will not feel insecure about how the marital assets are being managed. Postmarital agreements, again, require, because the parties are married, the highest fiduciary duty that is owed to each party, which means they have to disclose all of their assets, and each party must have counsel. California allows parties to engage in a premarital or postmarital agreement if they don't have counsel, only if the party who is representing a party fully explains to the other side what they're getting into. Most lawyers feel that that is a violation of their duty to the party they're representing and will require the person to have counsel. Most premarital agreements generally require each party to pay for their lawyer, and it has to be decided who's going to pay for each party's lawyer. The same thing occurs with postmarital agreements. Premarital agreements have increased in familiarity, and there is no longer the stigma of having a premarital agreement to promote divorce. The only thing that you can't really do is make sure that your spousal support obligation, if the marriage is terminated, will be binding. In California, we have something called a clawback clause, which says that even if you had counsel when you entered into your premarital agreement for spousal support, if that agreement becomes unconscionable at the time of its enforcement, i.e. when you get divorced, that agreement can be severed. So, for example, if someone becomes ill or gives up a career and they have agreed to a nominal amount of spousal support, which seemed reasonable in the first 3 or 4 years of the marriage, 15 years later, they may not be reasonable, and that postmarital obligation can be eliminated, and the court will use a normal set of rules to determine spousal support. There is no stigma anymore with respect to premarital agreements, and postmarital agreements sometimes, as indicated, allow parties to continue with their marriage with security as to how the community property is going to be dealt with going forward.